Looks good. Okay.
Hello, good morning.
Good morning, everybody. Melissa, are you ready to begin?
Yes, I am.
All right, thank you. It is 9 o'clock. And we are here for a hearing in case 23-00196 UT in the matter of Public Service Company of New Mexico's Renewable Energy Act Plan for 2024 and proposed 2024 rider rate under rate rider number 36. Public Service Company of New Mexico is the applicant. Today is Friday, September 1st, 2023. My name is Hans Muller. I will be the hearing examiner to preside over today's hearing. Let's go ahead and get started with appearances. PNM, please.
Examiner John Verheuel on behalf of Public Service Company of New Mexico, and with me is my co-counsel Christopher Atencio.
Okay. New Mexico Affordable Reliable Energy Alliance, which Melissa, I will be referring to them as NMAREA or NM area for purposes of the hearing.
Good morning, hearing examiner. Good morning, colleagues. Kelly Gould for NM area.
Good morning, Kelly. And utility division staff.
I think we have other parties as well, but I'll go ahead and make my appearance. I'm Bradford Borman, appearing on behalf of Utility Division staff.
Morning, Brad. There is one official transcript of this proceeding. I'm sorry, before I do that, did I miss anybody?
Yes, Mr. Examiner. Keith Herman on behalf of the Albuquerque-Bernalillo County Water Utility Authority. And we might get to this at preliminary matters, but I was going to request excusal as we do not expect to be very active in this proceeding.
Any objections to?
No
Thank you.
objection.
All right. Granted.
And good morning, Mr. Hearing Examiner. I'm Charles DeSalen, representing Coalition for Clean Affordable Energy. We are also not an active participant in this matter. We do not have any witnesses, but we're interested in the issue generally, so we'll be monitoring it.
Okay, thank you. If you do not, either of you are welcome. This is being streamed on YouTube. If you choose to watch it through YouTube, instead of being part of the Zoom, you're more than welcome to just watch solely through the YouTube stream. But I note that you will be monitoring.
Thank you.
Okay, anybody else? All right. The recording of the hearing, there is one official transcript of this proceeding. That is the transcript produced by our court reporter. She will supply that transcript to the commission and it will be maintained on eDocket. It'll be the only official transcript. No party is authorized to record this proceeding. Our court reporter will also collect exhibits from the parties and transmit them to the commission as the official record of exhibits admitted during this hearing. I gave you directions about exchanging exhibits utilizing Dropbox. PNM entered exhibits 1 through 10. NM area entered exhibits 1 through 9. And staff had 2 exhibits which were loaded shortly before beginning today. Does anyone need additional time to review those, as I know those were just recently uploaded?
No, but hearing examiner, I do have a preliminary matter that I would like to address at some point before the start of the hearing.
Yeah, I'll get to any pending motions and preliminary matters here at the end. All right, hearing none, just that anyone needs additional time. All the parties are in attendance. We'll go for an hour and a half this morning and take a 10-minute break. Lunch will be from noon to 1, and if we need to go beyond that, we'll wrap up at 5 p.m. today. To the extent that this interferes in any way with completing work, we will have another day of hearing, which I do not expect. This is principally for our court reporter so that she has time to rest during the day. And Melissa, at any time today, feel free to interject and direct people to either slow down or adjust their audio so you can hear.
Thank you.
Presentation of evidence in this case would follow 1.2.233B. So applicant, PNM will go first, then interveners, then staff. And could I have order of witnesses? PNM.
Our order of witnesses will be Nicholas Phillips, followed by Shane Gutierrez, followed by Thomas Baker, followed by Aaron Brash.
And NM area, your witnesses?
We have one today. It will be Greg Meyer.
And staff?
Good morning, Mr. Hearing Examiner. Staff has two witnesses. Mr. Tupler will present his testimony first, and then he'll be followed by Bamadou Ouattara.
Okay. Okay. The commission's initial order in this matter vested the hearing examiners with authority to conduct any necessary hearings and to take any other actions consistent with commission procedure. Under section 6264 NMSA 1978, the commission, and by extension through the delegation of powers, the hearing examiners also exercise broad power to supervise and regulate utilities in order to protect utility ratepayers and ensure that the utility provides reasonable and proper service at fair, just, and reasonable rates. To the extent that the hearing examiner asks additional inquiries during this proceeding, it is consistent with the delegation of that authority and practice of the commission. The scope of redirect then is matters arising from examination by the hearing examiner. Recross will be limited to matters arising from redirect. The basic import of these rules is to ensure orderly questioning. I checked with Anna Kippenbrock and she indicated that no one had signed up today for public comment, so we do not have public comment for today's hearing. Motions before me. I had the motion for administrative notice. PNM requested that I take administrative notice of the following pleadings or orders from case 2158 UT, which is initial comments. NM area's initial comments on notice of proposed rulemaking. NM area's response comments on notice of proposed rulemaking, the commission's final order from December 7th, 2022, and the commission's order granting SPS's motion for rehearing in part and denying in part EP's motion for rehearing. And basically, you're asking me to take administrative notice on this. The development of the language contained in subsection 1 of section 15 of Rule 572. Is that accurate, Mr. Verhall?
Yes, I think more critically, the development of that language in proposed section 15I of that rule lead to the fact that there is currently an order from the commission for the commission in due time to open a new docket for an inquiry into or not an inquiry, but to get input, to get comment on a revised section 15I so that it can perhaps be promulgated in the future. The commission was all set, I believe, in that rulemaking to promulgate and amended Section 15I, and they chose, upon the motion for rehearing from SPS, to then publish the rule without the revised Section 15I, and they did so on issues, I think, of notice. So the purpose of the order that's currently outstanding is to go in, revisit Section 15I, and provide all potential commenters and stakeholders with the opportunity to comment on Section 15I before it is ideally eventually promulgated.
So I just want to be clear on the record of what it is you want me to take administrative notice of. Am I strictly doing that, hey, we are developing language in Section 2158? Or am I taking administrative notice in that the commission should handle that in that new rulemaking?
Yes, I think it is the latter.
Okay. I am going to take administrative notice of the exhibits that you asked me to take administrative notice of. How I'm going to limit that notice, since there is not a current NOPR, notice of proposed rulemaking, moving forward at this point. I'm also going to take administrative notice, which is contained in that motion for a hearing, denying in part and denying in part. So I understand where you're coming from, but I am going to limit that administrative notice just to say there was attempted work on this language. It's still a work in progress. I'm going to reserve my notice and take opinions on, however, if that's the appropriate forum, and if that's the only forum that we should handle that in. But I understand the vantage point that, and I'm taking notice that the commission did decide not to issue that Section 15 in that rulemaking, and indicated that they would do a new notice of proposed rulemaking. That part I will take administrative notice of.
Mr. Hearing Examiner, if I may get some clarification on just administrative notice in general.
Yes, Ms. Gould.
So it's my understanding, and I understand that maybe perhaps the different hearing examiners have different approaches. So I have some issues that I'd like to raise, and I want to do it properly. But it's my understanding that if it's a commission order, there's not really a need to take administrative notice of it. If PNM wants to cite it in its brief, they can cite it. And really, it's just judicial notice. It's an order of the commission, and it's out there and it's law. And so that was my understanding of administrative notice, that it wasn't necessary for commission orders. I'm asking because I would like to cite to the commission recommended decision and final orders in case 19-00195 and 21-00215. It's my understanding that I can cite those cases in my brief without seeking this hearing examiner's approval to make administrative notice of those documents. But if I'm incorrect, then I would like to seek administrative notice of those documents as well.
Mr. Verhall, any objection?
If I could have a moment to consult with my co-counsel?
Sure. Ms. Gould, could you repeat for me the initial matter, the 19 case?
Yeah, so what I would be seeking
Just a number, please.
in my brief would be 19-00195. It would be the recommended decision. Let me get you the exact name. Recommended decision on replacement resources part 2, and then the final order adopting that recommended decision. And then the second order of the commission that I would be seeking to cite in my briefing would be 21-00215. It would be the recommended decision in this case, and then the final order of the commission adopting that recommended decision.
Okay. Thank you.
Thank you.
Mr. Hearing Examiner, are you waiting for me or are you doing something else?
If you have concluded your
I have, thank you.
consultation, go ahead.
I have, thank you, and I appreciate the extra time. PNM objects both on the basis of relevancy and on the basis of timeliness. With respect to relevancy, this is the very same issue that was discussed for hours at last year's case, and it's simply not relevant to this specific RPS case. The issue of how these resources are going to be classified should be handled as per witness Phillips's testimony and as per last year's ruling, should be handled in a more global rulemaking, which is why I asked for administrative notice of the rulemaking, which ordered that a future NOPR be opened in order to address that issue. So that's the issue of relevancy. The issue of timeliness, PNM requested administrative notice of the specific documents that we did in order to hopefully make this particular hearing go a little bit smoother. The issue here is, has PNM complied with the RPS or not? It's not how should these resources be classified. That's a completely separate issue. And per last year's hearing, it's irrelevant to this particular issue. So on timeliness, that's why we filed for administrative notice of those things, to put all the parties on record that not only does PNM believe that the appropriate venue for that issue is in a rulemaking with all potential stakeholders involved, but apparently the commission felt the same way in January of this year.
Okay. Thank you. Ms. Gould, I'll ask you, based upon your initial comments, I take it you are going to want briefing?
I will like to brief the issue. I don't think that this case is in proper place, and I don't think that in the last order or recommended decision, the commission made any determination on this issue. I would say that I don't think that there's a timeliness issue. These are orders of the commission. I think that we should be freely able to cite these in our briefs. I think that that was a discussion that we had in another pre-hearing conference with different hearing examiners, I understand, but there has been numerous writings on this issue that orders of the commission and recommended decisions are free game, they're a precedent. There's even a discussion in this in case 21-00117, where hearing examiner Medeiros goes to great lengths to describe how commission orders and recommended decisions don't need to be requested administrative notice of. The reason I brought it up is because I've never appeared before Your Honor, and I want to make sure that when I brief it, that I don't get an objection from PNM, but I don't think it's appropriate for administrative notice anyway. To the relevancy issue, if I may respond to that, Mr. Phillips on page 8 of his recommended, on page 8.
I think we're getting in. I think we're going to be getting into areas that.
I just want to respond to relevancy. Mr.
Yep.
Phillips talks about incremental cost. One of the reasons why I'd want to show, why I'd want to bring these orders in is to show the cost differential between renewables and non-renewable resources. I think it's fair game. I think it's definitely relevant to this proceeding. And I think that I can, cite to commission orders in my brief.
Okay, to the extent that you can cite them in your brief, I feel does not need me to rule on that. I think Mr. Verhall is more concerned. The reason I am taking administrative notice is that there's a pending motion before me that was done by Mr. Verhall. That to the extent that it would limit or not limit anything in your briefs, I think is kind of inconsequential. I would expect your briefing to be thorough. So to the extent that you are seeking essentially to be able to cite that in your brief, that would not be objected to by this hearing examiner.
Okay, thank you. That's all I'm requesting. Thank you.
Mr. Herman, I saw you had your hand up. Did you want to make a comment?
Not to get into a lengthy discussion about the purpose of administrative notice, but I was just going to second Ms. Gould's comment that it wouldn't be necessary to request administrative notice of everything we might cite in any brief, and that would be an impossible burden on every intervener and applicant in these cases if we were expected to file administrative notice of everything we intended to cite at our brief at a later date.
Okay, thank you. So to the extent that you want me to take administrative notice of that for today's proceeding, is it necessary? And I'll note and address the request for briefing at the conclusion of today's. We will work out the deadlines for briefing at the conclusion of today's hearing, Ms. Gould.
Thank you.
Is there anything else pending before we begin receiving evidence from anybody?
I
Mr.
had one,
Burwell? Ms. Gould.
I just had one other issue, and if it's not the hearing examiner's desire, I can move on. I wanted to move the hearing along. I wanted to state for the record who I had cross for and who I waived cross for. I don't know if that would be helpful at this juncture or not.
Let's just handle that. We don't have a real long line of witnesses. I don't feel that's necessary. I think we'll be able to address that with each witness.
Mr. Hearing Examiner?
Yes, Mr. Burwell.
I'm going to agree with Ms. Gould here. I think it actually is relevant. I sent out an email to all counsel about a week ago asking if they were interested in waiving cross-examination of any of PNM's witnesses. And the discussion there was that request was premature. However, based on last year's hearing where there was well over an hour of cross-examination for our first witness, Mr. Phillips, if there is no cross-examination for any of PNM's other witnesses, or for maybe only one of them, then PNM would request that they be excused, given that A, they've got a rate case to prepare for, and B, it's the day before a holiday weekend. So to that extent, if possible, I'd be interested in knowing who the parties plan to cross-examine, and if all my witnesses other than Mr. Phillips can be excused, I would request that.
I certainly, as staff's counsel, I certainly don't have any concerns about indicating right now that I don't have cross for any witness.
Yeah, and excuse me, we are preparing for a rate case and for staff, I don't have cross for staff, and so I would like to give them the opportunity to do other things rather than sitting in the hearing. If there are, I don't know if hearing examiner has questions for staff or if there's other parties that have questions for staff.
Okay, let me take this one by one. Mr. Verhall, do you have any questions for staff?
No.
Okay. So neither NM area or PNM have cross-examination for staff. I have one question for staff. So I think I will redo the witness examination so we can get people in and out of here. Ms. Gould, of PNM's witnesses, are there any that you waive cross-examination?
Yes, I waive cross-examination for Brash and Baker. I only have questions for Gutierrez and Phillips.
Okay,
And depending on how my cross-examination with Phillips goes, I may not have questions for Gutierrez, but I don't know yet.
okay. So let's, Mr. Verhall, if you do not oppose, let's do the two witnesses that she is waiving cross first, so we can get them in and out of here. And then we'll do Philip and then Gutierrez. Is that acceptable with you?
It is, as long as I can get them into the room quickly enough.
Okay,
Mr. Examiner, Keith Herman for the Water Authority. Just, I know I already requested to be excused. I was just sticking around for some preliminary matters, just to see if anything came up, but otherwise I will state that I waive my cross-examination for all witnesses and will be dropping off shortly.
okay, thank you, Mr. Herman. And do we expect cross-examination of Mr. Myers? Mr. Verhall?
Possibly. I would like to reserve some time if needed.
Okay, Mr. Borman?
As I've already indicated, I don't have any cross for any witness, so I can
Anyway, okay.
waive.
Okay, that being said, Mr. Verhall, would you object to having staff's witnesses go first since we've waived cross-examination, then we can excuse them?
No, no objection.
Okay. All right, I think that addresses that. So let's begin receiving evidence. Mr. Borman, call your first witness.
I guess my first witness then would be Mark Tupler.
Hi, good morning, everyone.
Good morning. Ms. Gonsalves, will you swear Mr. Tupler in, please?
Mr. Tupler, please raise your right hand. Do you solemnly swear the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, ma'am, it is.
Thank you.
Good morning, Mr. Tupler.
Good morning.
By whom are you employed and in what capacity?
I am a senior economist with the New Mexico Public Regulation Commission's Utility Division.
And as part of your duties in that position, did you review the RPS filing made by PNM in this case, along with the testimony filed with it?
Yes, sir, I did.
And based upon that review, did you prepare or participate in preparing testimony regarding that filing?
Yes, sir, I did.
Okay, you should have a document marked as Staff Exhibit 1. Do you have that document?
I do.
Okay, can you identify that document?
Yes.
What is Staff Exhibit 1?
Bear with me, it's coming up here. So It is titled Prepared Direct Testimony of Mark Tupler, dated August 16, 2023.
Thank you. Was Staff Exhibit 1 prepared by you or under your supervision?
It was prepared by me.
Okay. If I asked you today the same questions as are set forth in Staff Exhibit 1, would your answers be the same?
Yes, sir, they would.
Are those answers true and correct to the best of your knowledge?
Yes, they are.
Do you adopt Staff Exhibit 1 as your sworn testimony in this matter?
Yes, sir, I do.
Thank you, Mr. Tupler. Mr. Hearing Examiner, I move admission of Staff Exhibit 1.
Okay. Any objections to the exhibit? Hearing none, the exhibit is admitted.
Thank you. Mr. Tupler is available for any cross-examination that may be asked.
Okay, the parties have waived cross-examination of Mr. Tupler. I do have one question that will cover basically Mr. Tupler and Mr. Otero, Mr. Borman. At the bottom of page 20, line 20, there is a question posed to Mr. Tupler for his testimony. that he answers on page 21. The matter is addressed by staff witness, Mr. Otero. In reviewing Exhibit 2, which is Mr. Otero's commentary, I did not see that question addressed. So Mr. Borman, would you rather me pose that to Mr. Tupler or Mr. Otero for an answer to that question?
I mean, I guess in answering this as a lawyer, I'd probably ask both.
Okay. Then I will, that I'm just basically checking that with you. Mr. Tupler, then my question is, do you have, to the extent that Mr. Borman asked you if your answers would be the same, I did notice that we have a question that is basically unanswered between the testimonies, which is the question of does to the extent that PNM's request for commission approval be effective on January 1st, 2024, as proposed in its advice notice 606. Do you have any additional comments regarding that question?
The advice notice was not reviewed by me. So that could be an inadvertent question and answer in the testimony.
Okay. All right. I have no further questions for Mr. Tupler. Do you have any redirect, Mr. Borman?
I do not have any redirect for Mr. Tupler.
Okay. The witness may be excused.
Thank you, sir.
Thank you.
Mr. Borman, go ahead and call your next witness.
Thank you. I would call Bamadou Ouattara to the stand.
Do you,
Good afternoon or good morning, Mr. Ouattara.
Good morning, Mr. Papa.
will you raise your right hand, please? Do you solemnly swear the testimony you are about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I swear.
Thank you.
Just what my question? Okay. By whom are you employed and in what capacity?
Employed by the New Mexico Public Regulation Commission as a utility economist.
And as part of your duties in that position, did you review the RPS application made by PNM along with the testimony they filed in support?
Yes, I did.
Okay. Based upon that review, did you prepare or participate in preparing testimony regarding that application?
Yes.
Okay. Now you should have a document marked as Staff Exhibit 2. Do you have that document?
Yes.
So can you identify that document?
Staff Exhibit 2 is the prepared direct testimony of Bamadou Ouattara.
Okay. And was Staff Exhibit 2 prepared by you or under your supervision?
It was prepared by me.
Okay. If I asked you today the same questions as are set forth in Staff Exhibit 2, would your answers be the same?
Yes, my answers will be the same.
Are those answers true and correct to the best of your knowledge?
To the best of my knowledge, yes, those answers are true and correct.
And now you've heard the question that that the hearing examiner seeks to answer. Are you in a position to answer that question for him?
I would actually like to hear the question again.
Okay,
if that was
well, I
possible.
will let him ask it. With all that, do you adopt Staff Exhibit 2 as your sworn testimony in the matter?
Yes, I do.
Okay, thank you. Mr. Hearing Examiner, I move admission of Staff Exhibit 2.
Any objections to Staff Exhibit 2 being admitted? Hearing none. Exhibit 2 is admitted onto the record. Does that conclude your questioning, Mr. Borman?
Yes, I'm sorry. Yes, it is. That concludes my questioning. Mr. Ouattara is available for for the hearing examiner's questions.
Okay. A cross-examination of this witness was waived by the parties. Mr. Watera, I just have one question. During Mr. Tupler's direct testimony, a question was posed to him if staff supports PNM's request for commission approval of their renewable energy rider number 36 to be effective January 1st, 2024, as proposed in its advice notice number 606. He indicated that that question would be addressed by you. So I will pose that question to you. Does staff support the request for that energy rider to be effective January 1st, 2024?
Thank you for that question. Can you please give me a minute to go like over my own testimony? I might have answered that question somewhere.
Okay. Take a minute and review.
So, Mr. Hearing Examiner. Yeah.
Yes, Mr. Walker.
Yeah. In my testimony, like I did not directly like answer that questions, but the recommendations at the end like of my testimony basically says that staff recommends a PNM advice notice 606 be approved subject to any commission modification. And I will guess that will be on effective January 31st.
Okay, thank you. That answers my question.
Thank you.
I have no further questions. Mr. Borman, any redirect?
No, I have no redirect for Mr. Watara.
Okay. Witness is excused. Thank you, Mr. Watera.
Thank
Thank you, Mr. Watara. That concludes staff's witnesses.
All right. Thank you, Mr. Borman. All right. Mr. Verhall.
Mr. Hearing Examiner, my name is Chris Attenson. I'm co-counsel with Mr. Berkule, and will be doing direct for PNM witness Baker and Brash.
Okay. Thank you. You may call your first witness.
Thank you, Mr. Hearing Examiner. PNM calls Mr. Thomas Baker.
Ms. Gonsalves, go ahead and swear the witness in.
Do you solemnly swear the testimony you are about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you.
Good morning. Would you please state your name and job title?
Sure. My name is Tom Baker. I am a senior manager over cost of service and corporate budget. I'm employed by PNMR Services Company.
Do you have before you what has been labeled PNM Exhibit 9?
I do.
What is this document?
This is my direct testimony filed in this case on June 1st, 2023.
Was this prepared by you or under your supervision?
Yes, it was.
Is it a true and accurate account to the best of your knowledge?
Yes.
Are there any additions or corrections that you have to it?
No.
If I asked you the same questions today, would your answers be the same?
Yes.
All right, Mr. Hearing Examiner, I move admission of PNM Exhibit 9.
Any objection to PNM Exhibit 9 being admitted onto the record?
No objection.
Okay. Hearing no objection, the exhibit is admitted.
Thank you. And that's all the questions I have, and I would present Mr. Baker for cross-examination, if any.
Okay. Cross-examination of this witness has been waived by the parties. I do not have any further questions for Mr. Baker either. So, Mr. Baker, thank you for your appearance today. Mr. Baker, you are excused.
Thank you.
Thank you, Mr. Hearing Examiner, and if you'd bear with us for just 1 minute, we'll get Mr. Brash set up.
Yeah, thank you.
All right, thank you, Mr. Hearing Examiner. I believe we're ready to proceed with Mr. Brash.
Okay, Ms. Gonsalves, please swear the witness in.
Do you solemnly swear the testimony you are about to give will be the truth, the whole truth, and nothing but the truth, so help you God? Oh, I'm not hearing you.
Witness is on mute right now.
Can you hear me now?
Yes.
So you swear?
I do.
Okay.
Good morning. Could you please state your name and job title?
Yes, my name is Aaron Brosh. I am Senior Pricing Analyst employed here at PNM.
And Mr. Brash, do you have before you what's been labeled PNM Exhibit 10?
Yes.
What is this document?
This is my direct testimony filed on June 1st, 2023.
Thank you. Was this prepared by you or under your supervision?
Yes.
Is it a true and accurate account to the best of your knowledge?
Yes.
Do you have any additions or corrections to it?
No.
If I asked you the same questions today, would the answers be the same?
Yes.
All right, Mr. Hearing Examiner, I move admission of PNM Exhibit 10.
Any objection to PNM Exhibit 10 being admitted onto the record?
No objection.
Okay. No objection. Hearing no objection, PNM Exhibit 10 is admitted.
Thank you, Mr. Hearing Examiner. And with that, I would present Mr. Brash for any cross-examination.
Cross-examination of this witness has been waived by the parties, and the hearing examiner does not have any questions for Mr. Brash. So Mr. Brash may be excused.
Thank you.
Thank you, Mr. Hearing Examiner, and we will switch to our next witness here. Just bear with us for 1 moment, and thank you for your patience.
Thank you.
Mr. Hearing Examiner,
Yes, Ms. Beatles.
thank you. I would like to enter my appearance for Western Resource Advocates. I apologize for being late this morning. I'm having technical difficulties. I'm trying to get repaired, fixed before the rate case hearing next week, and IT had taken over my equipment. And when you let me into the Zoom, you were discussing waiver of witnesses, and I just want to affirm, of course, I don't object to anything that happened in my absence, and I affirm that I similarly waive cross for those witnesses.
Okay, thank you, Ms. Beatles.
Thank you.
Mr. Hearing Examiner, PNM calls Nicholas Phillips.
Okay. Melissa, go ahead and swear the witness in.
Thank you. Do you solemnly swear the testimony you are about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, I do.
Thank you.
Good morning. Please state your name and job title.
Good morning. My name is Nicholas L. Phillips. I'm the Director of Integrated Resource Planning for Public Service Company of New Mexico.
Do you have before you what has been labeled PNM Exhibit 6?
Yes, I do.
What is that?
That is my pre-filed direct testimony filed in this proceeding.
Was this prepared by you or under your supervision?
Yes, it was.
Is it a true and accurate account to the best of your knowledge?
Yes, it is.
Any additions or corrections to it?
No.
If I asked you the same questions today, would the answers be the same?
Yes, they would.
Mr. Hearing Examiner, move to admit what's been labeled as PNM Exhibit 6.
Any objections to PNM Exhibit 6 being admitted onto the record? Hearing none, the exhibit is admitted.
Mr. Phillips, do you have before you what's been labeled PNM Exhibit 7?
Yes, I do.
What is that?
That is my pre-filed rebuttal testimony filed in this proceeding.
Was this prepared by you or under your supervision?
Yes, it was.
Is it a true and accurate account to the best of your knowledge?
Yes, it is.
If I asked, are there any additions or corrections to it?
No, sir, there are not.
If I asked you the same questions today, would the answers be the same?
Yes, they would.
Mr. Hearing Examiner, move to admit PNM Exhibit 7.
Any objections to PNM Exhibit 7 being admitted onto the record?
No objection.
Hearing none, the exhibit is admitted.
Thank you. At this time, I offer witness Phillips for cross-examination.
Okay. Mr. Borman, do you have any cross-examine questions?
I do not have any questions for Mr. Phillips.
Okay. Ms. Gould.
Hi, good morning.
Good morning.
My name is Kelly Gould. I represent NM area. So I have questions for both you and Mr. Gutierrez. They kind of overlap. So if I ask and to try to get through, so perhaps I don't have questions for Mr. Gutierrez, I'm just going to ask them for you to you. And if it's more appropriate to ask Mr. Gutierrez, just let me know, okay?
Perfect.
So starting out, and again, these are more for Mr. Gutierrez, but maybe you can answer them. I was wondering if in Mr. Gutierrez's testimony, if you could direct me or tell me the costs of certain solar projects. So the first solar project that I was looking for the cost of was the Jicarilla solar project.
Is there a particular page in Mr. Gutierrez's testimony you would like to refer me to?
No, I couldn't find it in the testimony. That's why I have the question. But I guess I can direct you to.
And there are multiple Jicarilla projects on our system. Is there a particular Jicarilla project you are referring to?
I guess I was referring to the one that was coming online or is online. Let's see. Really what I'm looking for is I'm trying to get a lay of the land on many of these solar projects. And if I just way of background, some of the prices have increased from when they were approved. And so I'm just trying to figure out what the prices are. So on page 8 of Mr. Gutierrez's direct testimony, line 16, he talks about 50 megawatts Jicarilla Solar 1 facility. And let me go to Dropbox on NM area exhibit.
I'm trying to find the reference in Mr. Gutierrez's testimony here. I'm on page 8. Is there a line or?
Yeah, it's line 16.
Line 16.
So
Go ahead.
I was just looking at NM Exhibit 2, which is the recommended decision from 19195, page 42.
Bear with me. So you said that was exhibit, which one?
NM Exhibit, hold on, let me open my Dropbox bigger.
Yeah, I'm working with paper
Area.
copies here.
Exhibit 2, recommended decision part 2, 19-00195, recommended decision part 2, page 42.
Page 42.
And in that paragraph B,
Ms. Gould, I'm going to ask you to slow down just a little bit. Give everyone, including this hearing examiner, a chance to catch up to that page number.
sure, sorry, my apologies.
Okay, I'm here with you on page 42 of NM Area Exhibit 2.
Okay, paragraph B in the middle, it says, or I guess more at the end, the 50 megawatt Hickory PPA includes an energy purchase price of $19.73 megawatt hour. Is that, did I read that correctly?
Yes, the PPA solar portion of that contract was for $19.73 per megawatt hour as approved by the commission.
Okay, and the battery storage portion, it was $9.97 per kilowatt month. Is that correct?
I believe you're reading that correctly.
Okay, so my question is if you know if those prices remain or if they've increased.
Off the top of my head, I believe that they have stayed the same, but I would need to go into the contractual dockets because these were multiple contracts, right? And they, of course, were delayed that we know. Some of them had increased, some of them had not. I believe this one stayed the same, but I would need to go and look to be sure.
Okay. And then I have the same question. We can stay on the same page of the recommended decision. I have the same question for the Arroyo Solar battery project. Here in the recommended decision, in the middle of the paragraph, it says the 300 megawatt Arroyo PPA includes an energy purchase price of $18.65 megawatt hour, and the ESA charges a capacity price for 40 megawatts of battery storage of $7.46 kilowatt month. Do you know if that is, did I read that correctly?
You read that correctly. The solar portion was $18.65 a megawatt hour, and the battery portion was $7.46 a kilowatt month.
Do you know if that price has increased off the top of your head?
Off the top of my head, I do not. I do know that the size of the battery had changed from 40 megawatts to 150. You know, my recollection is that the prices stayed the same or very similar, but we would need to go to the actual filed amendments to the contracts to be sure, which I believe were in docket 20-00182-UT. Perhaps we could take administrative notice of that one.
20-00182 UT, that's where the updated contracts were filed?
That's my recollection, is that's for those updated contracts, as well as the two additional contracts that were required by PNM to go and negotiate were filed.
Okay, so that brings me to my next question. So I couldn't find the price for the San Juan Solar, but you're saying it would be in that 20-00182 UT docket.
Correct. Now that one, I do know the price had gone up on.
Okay, and so where would
all the amendments were filed in that same docket, but that one, my recollection, is one of the ones where there was an increase in price to that contract.
Off the top of your head, do you know the price of that project?
Off the top of my head, I do not.
Okay. Mr. Hearing Examiner, I ask if it's necessary for the court, for the hearing examiner to take administrative notice of the prices of those PPAs as presented in 20-00182-UT.
I'm not hearing you.
I'll take notice that it has been identified that that is the docket they are contained. I'm not, since we have not said the prices, I'm not going to take notice of the prices, but I will note that the witness has stated that that is the docket that contains that information.
Thank you. So my next question is for the Atrisco solar cost. And for this one, I will direct you to NM Area 7.
Objection. Mr. Hearing Examiner, I understand the point that Ms. Gould is making as to the prices of these renewable resources. I object to this line of questioning as it's not relevant to the question of whether or not PNM has sufficient renewable energy certificates for the current year, which should really be the only question in this case. I understand NM Area wants to raise the issue of the RPS rider and how the various resources are classified and the costs that go into the rider, but I object to these points being made on the basis of relevancy to this particular case.
Okay, Ms. Gould, how would you respond to the objection?
It's PNM's position that that's the only issue in this case, but it's clearly not the only issue in this case. NM Area has other issues. PNM is filing this case requesting an update of its RPS rider. So it is inherently relevant what they're including in the rider. And, I can ask these questions to Mr. Gutierrez. It might be in this filing, but I can't find it. All I can find is PNM listing these resources as at a $0 cost. And so I would like to know what the costs of those resources are, because PNM is clearly using those resources for RPS compliance.
To the extent that you feel the questions are more accurately posed to Mr. Gutierrez, why don't we do that?
Well, I don't want to wait. If Mr. Gutierrez doesn't know, then I've lost my chance to ask, because Mr. Phillips will be excused. So I'd like to, it's not going to take me very long. I have one more PPA to ask a question about the cost. And if Mr. Phillips doesn't know, or if he can direct me into the filing of where PNM lists these costs, then he can do that.
Okay, I'm gonna allow the questioning to continue. Obviously, I'll consider that in light of the total evidence presented during this, but I'll allow if you only have one more PPA to ask about, I will allow you to continue with your questioning.
Thank you. Mr. Phillips, if you could please turn to NM Area Exhibit 7. It's the 21-00215-UT compliance notice.
I'm at that exhibit. If you could direct me to a page number.
Sure. I'm on page 2, second paragraph, middle of the paragraph.
Okay.
So what I'm trying to get is the price of the PPA and the ESA for the Atrisco solar project, the Atrisco solar battery project. And in this document, it says, well, first of all, what is this document, if you could?
This document is titled Compliance Notice of Public Service Company of New Mexico of Second Amendment to Atrisco Energy Storage Agreement. It is filed in case number 21-00215-UT.
And are you familiar with this document?
I'm generally aware of this document. I was not the one who filed this or put this together.
Are you aware that there was a price increase for Atrisco solar and battery?
Yes, I am.
Okay, so I'm going to read from page 2. It says the key modifications of the First Amendment to Atrisco solar PPA included an increase in the price from $19.13 per megawatt hour to $23.63 per megawatt hour. Did I read that correctly?
Yes, I believe you read it correctly.
And is it your understanding that the $23.63 is the final cost of that solar portion of Etrisco?
Subject to checking the actual filed amended contract in that docket, I believe that was the last price amendment to this contract for the solar portion.
Okay, great. And then I'm going to continue. It says, similarly, the key modifications of the first amendment to the Etrisco ESA included an increase in the price from $6.68 per kilowatt month to $8.45 per kilowatt month. Did I read that correctly?
Yes, you do know how to read. I do believe you forgot the last part of the sentence, but you read the portion there correctly.
Okay, and is it your understanding that that's the final, the $8.45 per kilowatt month is the final cost of that Etrisco ESA?
For that portion of the ESA was also amended to increase the size from 150 megawatts to 300 megawatts. And the second portion of the ESA was at a different contractual price, if my recollection serves. Again, that would be subject to check to looking at the final filed contracts.
Okay, and is it your understanding that the final filed contracts would have been filed in 21-00215 docket?
I believe that is correct.
Okay. So of these 4 solar ESA projects that we've just discussed, if not for these projects, would PNM meet its RPS obligation of 20% in 2024, if you know?
That would be a better question for Mr. Gutierrez. I do believe the answer is yes, but you'll want to ask him to be sure.
Okay, thank you. And I have the same question I can ask for Mr. Gutierrez. If not for these projects, would PNM meet its 50% RPS obligation for 2025?
That's the incorrect RPS obligation for 2025.
Sorry, 40%?
No, we would need those resources to meet the RPS obligation in 2025.
Okay, so is
Now, the reason why those resources are listed as $0 in Mr. Gutierrez's testimony is because the commission ordered those to be recovered through the fuel and purchase power clause, and therefore we are not seeking recovery through the RPS rider.
Thank you for answering a question that I didn't ask.
You're welcome.
Is it PNM's position that these resources have a $0 RPS compliance value?
It's PNM's position that these resources were ordered to be recovered through the fuel and purchase power clause, and given the bundled rec and energy requirement, you cannot separate the renewable attributes from the energy cost that was ordered to be recovered through the fuel and purchase power clause.
But that wasn't my question. Is it your position that they have a $0 RPS compliance value?
Objection, asked and answered.
Sustained. Please ask your next question, Ms. Gould.
On page 6 of your rebuttal, oh wait. Hold on. Page 4 of your rebuttal, line 10 through 13.
I'm with you.
Okay. You state, for example, purchase power agreements are subject to 17.9.551 NMAC, which generally requires the recovery of associated energy costs through PNM's FPPCAC. Sorry, I'm going fast. As opposed to the RPS rider. Did I read that correctly?
You did read that correctly, recognizing that was the third paragraph or fourth paragraph of a answer. So that paragraph does not just stand on its own. It must be read with the full response to that question.
Well, my understanding of that statement is that you're saying that usually PPAs are recovered through PNM's FPPCAC. Is that not your intent?
The intent was to answer the question that was posed to myself on page 2, which is, can you provide some background on how PNM accounts for the cost of its RPS compliance? There was 4 different paragraphs explaining this rationale, and you must read the entire answer in order to understand the answer to the question, not just one part of it.
So this statement, the intent of this statement is not to say that PPAs must be recovered through the fuel clause.
That is one portion of the answer to my question of myself. There are a number of other portions to the answer to that question. Yes, my answer here is that generally speaking, purchase power agreements are subject to 17.9.551 NMAC, which generally requires the cost of the associated energy through the FPPCAC as opposed to the RPS rider. So it's not a one size fits all. There's a number of other pieces of my answer to this question. And that's what I was trying to point out.
Yes, and I'm just asking you about this portion. In the RPS rider, there are PPA costs that flow through. Is that correct?
There are PPA costs that flow through that have been ordered to be placed there by the commission. I believe earlier in the answer to this question, I pointed some of that out.
And one of those PPA costs that flow through the RPS rider would be for La Jolla too. Is that correct?
That's correct. And my understanding and recollection is that there was a specific determination made by the commission to move that to the fuel clause. I'm sorry, to the RPS rider.
Okay.
There was a specific determination made by the commission to recover the cost of the projects that we just spoke about through the fuel clause.
Right, but the commission can change its mind, right?
I do believe the commission is not bound by its prior decisions, but precedent is a good thing.
PNM is requesting that the commission address NM area's issue in a rulemaking. Is that correct?
That is correct. And as we agreed to with your witness in the previous case, that would be the appropriate place for this to be upheld. And the commission agreed with that in its order as discussed earlier prior to the start of the evidence examination.
Do you know if any other utilities in NM area in New Mexico's jurisdiction have voluntary program participants?
I'm unaware of that. Nevertheless, the other utilities do face the same renewable requirements, have the ability to have voluntary programs, and face the same cost recovery mechanisms available to it. So it is something that is important for all of the utilities and all of their stakeholders to consider.
But you don't know if other utilities have voluntary program participate.
Whether or not they have them today does not mean that they wouldn't have them in the future, and it would be an important issue for all to consider.
So last year, if you know, during the pendency of PNM's RPS case, there was a rulemaking docket open, which was 21-0058, which was revising the commission's renewable energy rule 572. Is that your understanding?
I believe that's correct.
Okay. Did PNM make any attempts in that rulemaking docket to address this NM area's issue, if you know?
I don't know off the top of my head. I know we had a couple of phone calls with NM area, but there was no resolution reached.
I wasn't asking about if you made any attempts with NM area. I was asking if you addressed the issue in the rulemaking docket with the commission.
Thank you, and I provided a complete answer.
Ms. Gold, could you clarify one thing for me? When you say NM areas issue, what issue are you specifically referring to?
NM area's issue is that PNM is not including all of the renewable RPS compliance costs in its renewable energy rider, in its RPS rider.
Thank you.
Is there any rule? I know I know that you say commission orders, but my question is there any rule or statute that makes a distinction between a quote unquote RPS resource and a quote unquote system resource?
Is there any
Motion
rule?
calls for a legal conclusion.
That you know of in your non-legal position at PNM?
I'm sorry, is the
Let me just address the objection. I hear the objection, but I don't think she's asking for his legal opinion on it, just his awareness. You can proceed to answer.
Would you please restate the question?
Yes. Do you know, is there any rule or statute that makes the distinction between a quote RPS resource unquote and a quote system resource unquote?
I'm unaware of any rule or regulation that makes a distinction between those resource types. I'm not sure, quote unquote, what you mean, but
The REA mandates that PNM has 80% renewable, that PNM is 80% renewable energy by 2040. Is that your understanding?
that is the final RPS target required under the Renewable Energy Act as amended by the Energy Transition Act.
And so won't all of, or at least 80% of your system resources have the dual function of providing RPS compliance and meeting other system needs?
Could you say the question one more time?
Won't 80% of PNM's resources on its system have the dual function of achieving the 80% RPS compliance standard and at the same time meeting PNM system needs?
I mean, I guess I'm not sure what you mean by dual function. The way that we introduce energy to the system is we dispatch the system and we design the system to meet all of our requirements and provide safe and reliable electric service. So yes, in 2040, at least 80% of the system needs will be met by renewable resources, and they will be supplying at least 80% of the system energy. Now, for example, you brought up voluntary customers, and as I noted in my testimony,
I didn't bring up voluntary customers.
May I finish my answer, please?
Yeah,
Well, if you're,
Ms. Gould, allow him to finish. This is really just for our court reporter's benefit. If you have an objection to what he's saying, just please state objection and I will address it. This is just to really get a clean record so our court reporter doesn't have two people talking over each other.
Now, in a previous dialogue a couple minutes ago, you brought up voluntary customers, and as one of the things that I mentioned directly in linkage to the 80% RPS requirement in the future was that the voluntary customers are not required to match their loads on an hour-by-hour basis. It's an annual requirement, and such other renewable resources on the system will be used to serve voluntary customers because of the diversification of the renewable resources on our system and the fact that we dispatch our system to meet all of our customers' energy needs. And so the idea of trying to say, well, any renewable resource should be fully and totally be placed into the RPS rider, which is avoided by voluntary customers, would create a cost shift, which is unfair to the other customers on the system.
what is your definition of incremental cost?
Is there a particular point in my testimony that you would like me to refer to?
Well, in your rebuttal on page 8, you discuss incremental costs, and I would like to understand what you think, what your definition of incremental cost is.
Sure. Let me reread the question and answer there to get the context that I'm speaking to.
Well, I'm not asking about this specific context. I'm asking what your definition of incremental cost is.
Well, you just referred me to a question.
Yeah, let's take a minute to review that page.
So what I'm referring to here
Can I
is,
ask my question? I just want to know I'm not asking you about this. I'm asking what your definition of incremental cost is. When I ask you about your testimony, you can tell me about it. That's not my question. You asked me to refer to some page in your testimony. I'm just asking for what your definition of incremental cost is.
Objection, Mr. Hearing Examiner. If counsel could limit the questioning here to what has actually been testified to, I think that's probably more appropriate than a question that's not tied to testimony.
I agree. Ms. Gould, are you basically stating in terms of PNM's Exhibit 7, page 8, that essentially what is he referring to when he refers to incremental cost? Is that an accurate summary of your question?
Yes.
Okay.
So the answer on page 8 refers back to a question at the bottom of page 7, which I asked myself, what is the fundamental question that must be addressed in such a rulemaking or workshop? So it's important to keep in mind that this is talking about our recommendation is that this issue that you're speaking about right now and determination of system energy versus RPS related energy should be done in a rulemaking or workshop. And if we were to go to a rulemaking or workshop, in my mind, the fundamental question about the workshop would be is whether or not there's an incremental cost to meeting RPS requirements above and beyond the cost to provide safe and reliable electric service for all customers. And I conclude by saying that that is the only portion of a renewable related cost that should be avoided by voluntary customers.
So my question remains, what is your definition of incremental cost?
And my answer was, as it is in my testimony, that the incremental cost that should be looked at in this rulemaking or workshop is the incremental cost to meeting RPS requirements above and beyond providing safe and reliable electric service for all customers. That is the answer.
In 19-00195, are you familiar with that case?
Yes, I am.
The commission approved a portfolio called CCA1. Is that your understanding?
The commission did approve a portfolio that is generally referred to as CCAE1. I'm not sure if that's exactly the language in the commission order.
And I was just doing it to be easy. That portfolio consisted entirely of solar and batteries. Is that correct?
That is not correct.
That's not correct?
No.
What else did it include?
It also included a requirement to look for incremental demand response and energy efficiency.
Okay. And PNM had a preferred portfolio in that case that included 7 gas plants. Is that accurate?
PNM put forward 4 portfolios in that case. The one that PNM had entered into contracts for and called its preferred portfolio was a combination of solar and battery storage, standalone battery storage, and 7 gas units, yes. And
I know that this approximation might be dated, but in the 19195 case, the CCAE1 portfolio was estimated to be $72 million on an NPV basis, more expensive than PNM preferred portfolio 1. Is that your recollection?
I'd have to go back and look at the information in the case.
Okay, if you could turn to NM area 2. The recommended decision from 19-00195 UT.
Okay, and is there a page in?
I do, yes. Page number 77.
77.
And it's actually 75. It's a table, so to get the whole table, it would be 75 to 77.
Okay, let me look back over this table really quickly.
Sure.
Okay.
So this table, my understanding is that it's showing the difference over a 20-year NPV of the the different portfolios that were put forth to the commission. Is that your understanding of this table?
There's two different tables. There's one that's on page 75 going into page 76. And I don't see the CCAE one portfolio there. The table on page 77. Is that the one you're asking me to look at?
Yeah.
Okay.
Would it be fair to say that the CCAE one portfolio was $72 million more than the PNM preferred portfolio?
Objection. Mr. Hearing Examiner, I apologize. This is probably the second time I've objected on this particular point, but just due to relevance and now a cumulative amount of evidence, you know, I think we're a good 40 minutes into cross-examination of Mr. Phillips, and counsel is still attempting to make the point via cross-examination that these renewable portfolios are more expensive than certain other potential mixes. And I think at this point it's getting repetitive.
Ms. Gould, and this will go to, I mean, I feel the table stands for itself. Is there any specific questioning on the table that you wanted Mr. Phillips to address?
Well, I would just like to respond to Mr. Verheul, if I may. This is the first line of questioning where I've delved into whether or not the renewable projects are more expensive. The first line of questioning was just getting a baseline of the costs. I have this question, and I also have a question based on the Palo Verde cases. Mr. Phillips directly testifies in his rebuttal testimony to the incremental costs of the renewables, and whether or not that incremental cost should be, he basically says that that's what should be calculated as RPS costs. So it's in my right to probe what the incremental cost of these resources actually is. And I don't think it's cumulative. I think it's directly relevant. I have this line of questioning, and then I have one other for the resources that were approved in the Palo Verde cases. If you don't want the witness answering the question, I could just admit this as an exhibit. I just wanted to ask whether or not he knew that the renewable portfolio that was approved was $72 million more expensive than PNM's preferred portfolio.
Mr. Hearing Examiner, I would suggest that if counsel would prefer to admit it either through her own witness or via briefing or as an exhibit in some other way, it's not necessary to ask questions of Mr. Phillips when, in your own words, Mr. Hearing Examiner, the table and the numbers in the recommended decision speak for themselves.
Well,
I don't see a potential issue to their admission under her witness. It is their exhibits that they're seeking. I don't see any particular reason why they would not be admitted, since as I've indicated. So Miss Gould, let me just ask too, because we're coming up to our break period. If in fact those documents were to be admitted, how much more time do you anticipate for cross-examination?
I don't have much more time, but I am confused about how I would admit this exhibit with my own witness. I don't get to question my own witness, so I don't understand the directive to get this evidence in through my own witness. I can address it in briefing, but I'm asking Mr. Phillips if he knows, and I have a follow-up question based on his rebuttal testimony on incremental cost. And so these questions are directly relevant to that final question that I have. After this line of questioning, I only have a question based on the difference between the portfolios in the 215 docket, and I believe I'll be done in 10 or 15 minutes, depending on how long Mr. Phillips decides to answer the questions.
Mr. Verheul, do you have any objection to me Since it is a recommended decision that has been posted in case number 19195 UT, admitting that onto the record right now.
I have no objection, Mr. Hearing Examiner.
Okay. That is admitted.
Thank you. If you know, well, let me,
And Ms. Gould, I intend, I'm going to stick to my schedule. We have 6 minutes before our break. If you can you conclude in that time?
I'll do my best.
Okay, thank you.
In the 21-00215 docket, are you familiar with that docket, Mr. Phillips?
Yes, I am.
Okay, PNM put forth two different portfolios. One was called the no new combustion portfolio, and the other portfolio was called technology neutral portfolio. Is that correct?
Yes, it is.
And the technology neutral portfolio contained aeroderivative gas turbine. Is that correct?
Subject to check, I believe there was one gas turbine in the portfolio period and then generics thereafter. So we can't just talk about, one small difference there.
And then the no new combustion portfolio contained obviously no gas. Is that accurate?
It contained no new gas. There was still the existing gas fleet.
Right. Do you have a recollection of the difference in costs between the no new combustion portfolio and the technology neutral portfolio?
Off the top of my head, I do not. I believe that the technology neutral was a bit less costly. However, a lot of that was attributable to things in the future, not just with that portfolio that was being introduced at that time, because the portfolio analysis did consider generic resources as a part of the tail end portfolio that would attribute to certain cost differences as well. And if we're getting back to this whole question and answer on incremental cost, again, I stated this in the context of this needs to be considered in a workshop or rulemaking. And my statement specifically that talks about in PNM's most recent cases to replace San Juan Generating Station and Palo Verde Nuclear Generating Station, these renewable portfolios reduce the cost to customers. And that's why I said there was no incremental cost. Comparing these to a hypothetical that was not approved by the commission, as well as the fact that costs have changed due to COVID supply chains, natural gas prices have gone up and other such things, does not make a good point of comparison. The fact is that these portfolios would have reduced costs even though they were adding all renewables.
Okay, and so in the 21-00215 case, the commission approved the no new combustion portfolio. Is that correct?
That's correct.
Okay, and if you could,
Reduce cost to customers.
I'm sorry, I didn't hear that.
And the corresponding portfolio would have reduced cost to customers.
if you could turn to NM area exhibit 5, which is the recommended decision in 21-00215, page 48 and 49.
There with you.
There's 2 tables on page 48, is that correct?
That is correct.
One is titled No New Combustion, and the second is titled Technology Neutral, is that correct?
That is correct.
And then I'm going to read from the recommended decision. The table from the bottom on page 48, the tables also reveal as onward emphasizes that PNM's no new combustion resource portfolio will cost customers over a 20-year period $6,327 million, which is $144 million more than the 20-year cost of the model technology neutral scenario. Did I read that correctly?
You did read that correctly, but I reemphasized my previous response that that portfolio was not approved, and what was approved reduced cost for customers. And so the statement in my testimony referring to incremental cost was talking about the fact that the solar portfolios and battery portfolios that were approved in those cases showed cost decreases to customers over the existing status quo.
Mr. Hearing Examiner, can I move to admit this NM area exhibit? I guess I need to title the one that I admitted before as NM area exhibit 1. Or how would you like me to do it? Would you like me to keep the nomenclature that's in Dropbox, or would you like it to be numeric?
Now, we're gonna keep the nomenclature that's in Dropbox for sake of the court reporter, otherwise we are gonna get crisscrossing sideways.
Okay, so just,
Mr. Verhall, I am noting that once again, this is a recommended decision that has been published. Do you have any objection to its admission?
As a general statement, no. As a matter of relevance and timeliness, yes, but I understand.
I'm just doing admission, so.
Understood. Understood.
Everything is admitted to this hearing examiner, and I'll give it the due weight that it deserves under the total weight of the evidence.
Understood.
So on the admission basis, do you have any objection?
No.
Then I am admitting what has been labeled NM Area Exhibit 5. Is that correct, Ms. Gould?
that's correct.
And that'll be admitted onto the record.
And just for clarity, the other admitted exhibit was labeled NM Area 2.
That is correct. NM Area 2, the prior recommended decision, that is the exhibit that was admitted. All right, we are at 10:30.
I have one more question.
I'm going to allow 2 minutes for it. Go.
Mr. Phillips, do you think that the commission approved these no new carbon resource portfolios in 19-00195 and 21-00215 due to the mandated REA to be 80% renewable by 2040 and 100% carbon free by 2045? Do you think they took those mandates into consideration when they approved these portfolios?
Objection calls for speculation.
Sustained.
Okay, that's all I have. Thank you.
All right.
My cross-examination.
Thank you, Ms. Gould.
I will say, I have only one or two for Mr. Gutierrez, just the couple that Mr. Phillips could not answer. Thank you.
Okay. We're going to take our 10-minute break, give the court reporter a break, and when we come back, we'll go into redirect for your witness, Mr. Verhall. All right, we are on break, off the record. Melissa, did you need anything from that? You're on mute.
Of course I am. I will make sure I have all of the exhibits. I think I only had, I've got to check and see what I have.
Okay.
All right, thanks.
All right, thank you. Since we went, so we're still off record, since we went over, I'm just allowing one more minute before we resume.
Fine.
Okay, I have 10:42. Let's go back on the record. Ms. Gonsalves, are you ready to begin?
Yes, I am.
Okay. And Mr. Verhall, go ahead, and I believe you with redirect for your witness.
Thank you, Mr. Hearing Examiner. I don't have any redirect questions for this witness, so I suppose that means if you have any questions.
I have one, and Mr. Verhall, you can indicate if you prefer me to ask this of a different witness, but I feel this is the correct one. To the extent that PNM has taken a position that the definition should be handled in section 115 in the rulemaking, which the commission has indicated they will issue a notice of public rulemaking on that at some point, either later this year or first quarter of next year. To the extent that that rulemaking does not complete itself by the filing requirement of next year, what would PNM's position be to address that?
Just to clarify your question, Your Honor, if the rulemaking is not complete to address how we might categorize different types of resources, system versus RPS, how would we handle it in the next RPS plan filing?
That is correct.
Yeah, I don't know that we have thought about that. I would probably want to meet with all of our customers or customer representatives and see if there was something that could be reached on behalf of all of our stakeholders that could be agreed upon. I mean, the idea here is that the issue raised is something that affects the cost that we charge to every single one of our customers. And so we want to at least get customer input prior to coming up with a new methodological approach, not just a single subset of customers.
Okay, but to the extent that that's already been done in part, correct? Because there was the rulemaking in place to the extent that the commission essentially punted it down the road rather than published it. You already have some stakeholder insight into that, correct?
That's correct. I think we would still want to make sure we went back to all of our customers and did our best to reach some agreement. If we did not, we would probably continue with the current approach until there was a culmination of that rulemaking.
Okay. I have no further questions. If you have any redirect for my questions, Mr. Verhall.
I don't, Mr. Hearing Examiner.
Are there any other question? I don't believe anyone else had, Mr. Borman had indicated, Ms. Gould had completed. So I believe that concludes the testimony for this witness. Witness may be excused.
Thank you.
Please call your next witness.
PNM calls Shane Gutierrez, and it may be a minute or so before he gets situated in our witness room. I apologize for the delay. It's just how we've got it set up here.
So you might have to hit that. Let's see.
Mr. Gutierrez, are you ready?
Sorry about that. Can you hear me?
We can.
Okay, I'm ready.
Go ahead and swear the witness in.
Raise your right hand. Do you solemnly swear the testimony you are about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you. Oops, I'm not hearing you.
Can you hear me?
I'm sorry, the Mr.
Oh,
I apologize. You're on mute, your name. Yes.
Are you having trouble hearing him? Because I can hear him, Ms. Gonzalez.
No, I can hear him, but I wasn't hearing him just now when I saw his lips moving, but maybe I'm just not quite here yet.
oh, sorry. Hopefully you can all hear me.
I can hear you fine. I can
Okay.
hear everyone.
Okay.
And then just to confirm for the record, he did swear or affirm to tell the truth for the record.
Yes, I heard that.
Okay. All right, thank you. Proceed.
Please state your name and job title.
My name is Shane Gutierrez, and my title is Senior Project Manager in our Planning and Resources Department.
Do you have before you what has been labeled PNM Exhibit 8?
I do.
Please describe that.
That is my pre-filed direct testimony and exhibits.
Was this prepared by you or under your supervision?
Yes, it was.
Is it a true and accurate account to the best of your knowledge?
Yes.
Do you have any additions or corrections to it?
No, I do not.
If I asked you the same questions today, would the answers be the same?
Yes.
Mr. Hearing Examiner, I move to admit PNM Exhibit 8.
Any objections to PNM Exhibit 8 onto the record? Hearing none, the exhibit is admitted.
I offer the witness for cross-examination.
Any cross-examination, Mr. Borman?
Staff has no questions for Mr. Gutierrez.
Okay, thank you. Ms. Gould.
Thank you. Hi, good morning, Mr. Gutierrez.
Good morning.
My name is Kelly Gould. I represent NM area. So I just have a couple questions for you. If you could turn to page 8 and 9 of your direct testimony.
Okay.
And this is just a reference point. My question is there anywhere that you know of, either in your testimony or in PNM in this application, that lists the prices of the Hickory Solar Project, the Arroyo Solar Project, the San Juan Solar Project, and the Atrisco Solar Project?
Not that I'm aware of.
Okay, thank you. My other question is, if not for these projects that I just listed, would PNM meet its RPS obligation of 20% for 2024?
Sorry, so you're asking if these resources that you just mentioned, Hickoria, the 50 megawatt Hickoria solar, 300 megawatt Arroyo solar, 200 megawatt San Juan solar, and 300 megawatt Atrisco solar. Are you saying if those were not counted for RPS compliance, would we still meet compliance in 24?
Yes, if those RECs were not used, would PNM meet its 20% RPS compliance for 2024?
Give me 1 second.
Sure, thank you.
So if I were to add up the projected RPS or RECs that we can use for RPS in 2024 for Hickoria Solar 1, Arroyo Solar, San Juan Solar 1, and Atrisco Solar, if I sum those up, I get 1,416,866 megawatt hours.
Can you repeat that number? 1416866.
866. That's right.
Thank you.
If I just compare that number to the amount that we are banking, if you can turn to my PNM exhibit SG2, page 3 of 3. I'm sorry, it should be 2 of 3, but the second page.
Oh, yeah, I'm there.
So if I sum up the lines, column A, lines 24, 25, 26, 27, I get that 1.4 million figure of RECs. That, if I sum those up, those are still lower than the amount we would bank there on line 35. So that tells me right away that even if we excluded those resources, we would still meet our RPS requirement of 20% in 2024.
Okay, that's helpful. But you will be banking those 1416866 megawatt hour RECs. Is that correct?
We propose to bank, I don't know specifically which RECs we need to bank, but if we chose to just bank those ones, it would amount to that 1.4 million.
Okay. And then those RECs would be used to meet PNM's RPS obligation for 2025 of 40%. Is that your understanding?
Yes, that's how we intend to use the banked RECs. We intend to utilize the older vintages first to try to meet RPS compliance, and then save any newer RECs, newer vintage RECs for future RPS compliance.
Okay, so I have the similar question. If not for these projects, the Hickoria 1 project, the Arroyo project, the San Juan project, and the Atrisco Solar project, if not for those projects, would PNM meet its 40% RPS obligation in 2025?
Yeah, that one's harder to project. I would hesitate to say that we would. I would need to do a calculation to make sure that, see what our position is, but.
Well, wouldn't you subtract this number that you just gave me from the bank and then go to your projections for 2024?
Sorry, Ms. Gould, let me interrupt because I want to keep this clear for myself as well. I believe the number he previously gave was for 2024. I don't believe he gave a number for 2025 because that's a different edition. So can we ask him? Can we ask him to do the math real quickly for 2025?
Yes, please.
Okay.
I can do that. Give me a second.
Yeah, thank you.
Okay, so my calculation is showing that if I just summing up those same projects for 2025, I get 2,398,225 RECs. Now, can you restate your question? I guess I'm getting a little confused on what the question is here.
Yeah, so my question is, if not for the projects that I listed, do you need me to list them again?
No.
If not for the projects I listed, would PNM meet its 40% RPS obligation in 2025?
Okay, understood. So if you didn't have those projects for 2025, we would not meet RPS compliance.
Okay. Thank you. And next year, PNM will be filing its RPS case for 2025 compliance. Is that correct?
Yes, just to clarify, when we file a plan, we always focus on the plan year as it's stated in the rule. So that would be the best estimate of the plan year for that RPS plan. So next year we'll file a plan year of 2025 and on how we're going to meet our RPS compliance.
Sorry, I'm looking for my last question, but oh, here. So in these exhibits that you've referenced, PNM SG2, page 2 of 3, even though it says 3 of 3, page 2 of 3 and page 3 of 3. Page 2 of 3 is for 2024, right? And page 3 of 3 is for 2025. Is that correct?
Yes, that's correct. Just to clarify, on the bottom of the page, it shows the wrong page pagination, but at the top right, it shows the correct ones.
Okay, great.
Sorry about that.
But my discussion of what they are is accurate. Is it not?
That's correct. Just to clarify, page 2 shows 2024 compliance, the details, and page 3 of 3 shows 2025.
Okay. And on lines 24, 25, 26, and 27 of both exhibits, you list those projects as a cost per megawatt hour dash rec of $0. Is that accurate?
That's correct.
Okay. And those recs in 2024 from those projects, well, I guess you said might be banked for compliance in 2025. Is that accurate?
What we'll do is once we get to the year where we actually show on-year compliance, instead of a projection, we'll account for the vintages of RECs that we have in place. And at that time, we'll make a determination of which RECs that we want to retire for compliance and which RECs we want to keep in the bank. So it's hard to say right now, but typically, like I said before, we'll retire the oldest RECs first, and the newest RECs, the newest vintage RECs, we'll keep in the bank for future compliance.
Okay, so what I hear you saying is that we don't know yet. We'll know next year. We don't know yet if these resources are going to be used, if the RECs from these resources are going to be used to meet PNM's 2024 RPS compliance. Is that accurate?
No, that's not accurate. I would say that, what I'm trying to do here is an accounting of all the RECs that we have at our disposal to meet our RPS compliance. And, if you look at what I'm saying we're going to have just from a total point of view, what's going to be in the bank, I'm not defining specifically which resources those are coming from yet. Those will be determined when we file our annual renewable report. So I'm not making that determination now. I'm just showing what our position is. But I am showing that these resources will help us meet RPS compliance, whether they're used for RPS compliance once we get to 2024, or we're going to use them for future RPS compliance. So I don't know yet.
Okay, thank you. That's all I have. Thank you.
Any rebuttal questions, Mr. Verhall?
I have no redirect for this witness. Thank you.
I do not have any questions for this witness either. So witness may be excused.
Thank you, Mr. Hearing Examiner.
And PNM, I believe that concludes your witnesses.
It does, Mr. Hearing Examiner.
Okay. So the only witness we have left is NM area. So Ms. Gould, please proceed.
Hi, good morning. My name is Kelly Gould. For the record, I represent New Mexico Affordable Reliable Energy Alliance, also known as NM area. I have my witness here on the screen. Can you please introduce yourself and spell your name for the record?
Hold on.
Well, let's hold on. We need to swear.
Sorry,
Ms. Kelly.
That's okay. I knew I would forget somebody somewhere. Do you solemnly swear the testimony you are about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you.
Can you please introduce yourself and spell your name for the record?
Sure. My name is Greg Meyer. GREGMEYER.
And who are you employed by?
I'm employed by Brubaker and Associates, Inc. as a principal.
Who are you providing testimony for today?
I'm providing testimony on behalf of New Mexico Affordable Energy, New Mexico Affordable Reliable Energy, or NM area.
You have in front of you what has been marked as NM Area Exhibit 1, titled The Direct Testimony of Greg R. Meyer on behalf of New Mexico Affordable Reliable Energy Alliance, August 16th, 2023. Is that correct?
That's correct.
Is this an accurate copy of your testimony in this case?
It is.
Was this document prepared by you or under your supervision?
It was.
If the same questions were asked of you today, would your answers be the same?
They would.
And are these answers true and correct to the best of your knowledge?
They are.
I ask the hearing examiner to move into evidence NM Area Exhibit 1.
Any objections to NM area Exhibit 1 onto the record?
No objection.
No objection.
Hearing no objection, the exhibit is admitted.
Thank you. I pass the witness for cross-examination.
Mr. Bradford, any examination? I'm sorry, you had already said you did not have cross. Sorry.
I do not have cross for this witness.
Okay. Mr. Verhall?
I have no questions for this witness.
Give me 1 minute. I just want to ask Mr. Meyer one question. On page 11 of your direct testimony that we just submitted, You indicate that you did propose language in the rulemaking docket, which is 2158 UT, to address the issue. However, the commission has not issued the notice of public rulemaking to forward that and proposed language. And so you're recommending basically that this hearing examiner remedy the issue in this docket rather than through the public rulemaking. Why should this hearing examiner address that now when there is essentially an open rulemaking? Or at least it should be renoticed in that rulemaking to make a final determination as to the definition.
Well, if my statement on 11 is really that in the last case, we raised this exact same issue, and that in that case, we noticed and discussed that it could possibly be resolved through that rulemaking. It wasn't resolved, at least I was informed that it wasn't resolved from my counsel. And so in order to get this issue resolved, since it wasn't resolved in that rulemaking, we've now come forward and said it should be addressed here. If there is some assurances that this issue can be resolved in a rulemaking, the current rulemaking that you cited, then we would be active participants in that rulemaking, and we would hope that this issue can be resolved in a timely manner, because each year that this goes on, voluntary customers are paying in excess of what they should because all the costs are not included in the RPS.
Okay. Thank you. I have no further questions. Ms. Gould, do you have any questions in lieu of my questioning?
No.
There are no other questions for this witness. He may be dismissed.
Thank you.
That concludes our witnesses and evidence onto the record this morning. Let's address briefing as Ms. Gould requested briefing. I know we have statutory deadlines once the transcript is produced onto the record by our court reporter. Knowing that we have other very large cases before us coming this month, are there any requests from the parties to deviate from the briefing deadlines to allow for an extension of time for briefing? Ms. Gould.
I believe it's up to the commission or PNM. I'm not, I will adhere to whatever the commission decides. I will state that while I do plan to submit a brief in chief, I will not submit a response brief. So my involvement will be limited to an initial brief in this case.
Okay, thank you. Mr. Brohall, do you need any additional time? I know PNM has a busy month.
We do, Mr. Hearing Examiner. Thank you. At this time, I don't see a need to deviate, but at the same time, I haven't seen the briefing order from you as to what issues you would like briefing on. So I would reserve the right to, if we do need extra time for some reason, to file a motion for additional time.
Okay. I'll probably address that in my briefing order. I mean, from both parties, obviously you are free to brief on whatever subject areas you would like to bring to my attention. Beyond that, what I'm interested in hearing, what I'm hearing from NM area is obviously we have been kicking this can down the road. I've taken administrative notice that the original rulemaking was back in 2020. And we still haven't issued a NOPR for section 15, subsection 1 of section 15 of that rule yet. So that'll probably occur either in this last quarter or first quarter of next year. And the rulemaking we'll see how long the rulemaking takes to get in place. What I'd be interested in hearing from the parties, and as NM Area's witness stated, if there's assurances that we're making progress on this, that they would be satiated. In the event that rulemaking does not occur, does not transpire to give a new definition prior to next year's filing by PNM, would PNM proffer to have that definition, or at least submit an alternative version? I'm kind of trying to put a line in the sand. Hopefully the commission does a rulemaking, but I also hear NM Area's concern that we've been kicking this down the road for 3 years. So in the briefing, I'd kind of like to hear what PNM or what NM Area would expect in a 2025, because we don't have a rulemaking right now for 2024. I checked with Office of General Counsel, and they don't expect this NOPR to hit until last part of the year, if then. So I'd be interested in hearing points from both sides on essentially what would we do then, so we can address their concerns, but under the current rules, I don't have a definition. So I would be in your briefs. Like I said, you can brief on whatever you would want this hearing examiner to review, but at some point of that brief, I would like you to take a look at a proposal for 2025. Maybe we can reach an agreement on that if a NOPR isn't in place. If a new rulemaking is in place, well, that trumps that, obviously, and we'll go with whatever that rulemaking happens. But if there is not a new rule in place by then, I would like to hear from the parties if they're open to alternatives at that time, because I think from what I heard today, honestly, is both sides are a little bit tired of doing the same argument. So I'd like to kind of reach a consensus here. If a rulemaking is not in place by this same time, 2024, excuse me, for the 2025 plan. So I would appreciate the parties giving me some input into that, because I may or may not make a recommendation to the commission based upon what I hear in your briefing. Beyond that, I probably will allow for an extension, because I know everyone's busy this month, so I will probably issue that in short order. You can expect that first part of next week, probably Tuesday with the Monday holiday. Beyond that, are there any additional questions?
Mr. Hearing Examiner, I don't have additional questions. I do want to clarify, I'm not certain how much you went through. I believe it was PNM Exhibit 5, which is the January 2023 final order on remand. But just to clarify, I think, and you can stop me if you know this, but the commission sounded very ready to promulgate this new section 15I, or I should say amended section 15I in the prior rulemaking. So I imagine that they already have what the commission believes is pretty good language to issue in the notice of proposed rulemaking, and it should be a fairly limited proceeding. And my hope would be that it could go fairly swiftly.
I would agree with you. That would be my hope too. But having done rulemakings with the current commission, who knows?
I don't think there are any quick rulemakings at this point in time.
Right. So I share your optimism, I just like to throw a little bit of realism into the mix as well. Like I said, I hope there is a rule in place by this time next year that we're not having this same discussion. If that does not happen though, for one reason or another, I know we have kind of ranked rulemakings right now to give them kind of a prioritization list. So that is my concern of when that notice of public rulemaking actually happens. Once it happens, I hope it will happen efficiently and quickly. But you can never quite guess rulemakings in terms of how quickly they're going to turn out. Does that end? Does that say it?
I think we agree, Mr. Hearing Examiner.
Okay. All right. I'll get the order for briefing out. Like I said, it'll probably not be filed until Tuesday morning with the holiday here. Ms. Gonsalves, do you have any questions?
Nope, I checked, looks like I have 2 exhibits from Mr. Borman, and the rest, I had the 2 files for PNM and NM area. So I should be good for exhibits.
All right, with nothing else, we are concluded. Everyone have a good Labor Day weekend. Even if you're going to be laboring away during Labor Day weekend with everything that is ahead of us this month. So thank you, everyone. We are concluded.
Thank you, Mr. Hearing Examiner.